I'm very honored to be invited to address you. I think that I speak for most of us when I say that the first thing we do as we wake up in the morning is to check our phones. In my case, it's very much the first thing that I will do, to check WhatsApp and Twitter to see get a sense of what's happening in the world. There's this term of FOMO, fear of missing out. Have I missed anything during the night? Are there issues in the media that I need to know about? Or just to check up on family and friends, what messages they've sent me. And many of us will feel a sense of panic without our phones because it makes us feel disconnected from the world. And I think it's that sense of connection, that feeling of not wanting to miss out, of wanting to be part of something or just commenting on issues that makes social media quite addictive. As we know, social media and user-generated content can take the form of text posts, images, videos, comments, and network platforms. It's extremely easy to upload your videos and pics, send it to your WhatsApp groups, and nearly immediately an entire range of people know exactly what you're doing. And these people can then send it on to other people, who send it to even more people, who then upload it to various different platforms, and within minutes, your WhatsApp message, your tweet, video, or pic has gone viral. Now, this may be all well and fine, but on the other hand, it can all go disastrously wrong very quickly, depending on the content. So I'm sure you remember Mr. Adam Katsavelos, who in August 2018, made a selfie video on a beach in Greece, where he made a racial slur using the K word with reference to black South Africans. He sent it to what he thought was a group of close friends, but the video went viral. The South African Human Rights Commission took him to the Equality Court, and in August 2019, he was ordered to pay 150,000 rand to the Seth Mazibuko Legacy Foundation and to apologize publicly. 4 months later, he pleaded guilty to criminal injury in the Randburg Magistrates Court and received a sentence of 50,000 rand fine or 2 years imprisonment, suspended for 5 years. There's another case which you may remember, a bit of an earlier one. Justine Sacco. She, in 2013, before boarding her 11-hour flight from London to Cape Town, tweeted, and I quote, "Going to Africa, hope I don't get AIDS. Just kidding, I'm white." Now, she was rather ironically the communications director for an internet company. But she boarded, and while she was in the air on this 11-hour flight, that tweet went viral. It was a huge storm. She arrives in Cape Town, switches on her phone, discovers this endless stream of messages responding to that tweet, and also discovers an outrage at that tweet, and also discovers, I think towards the end of it, that she's been fired because of this tweet. So all while she was in the air. So she tried to delete the tweet, delete her Twitter account, but it was too late, and she was dismissed for her hateful statements. The power of social media lies in the sheer magnitude of the number of people using it. According to the international market and consumer data company Statista, in 2020, over 3.6 billion people were using social media worldwide, and this number is projected to increase to almost 4.41 billion in 2025. As far as South Africa goes, the Worldwide Works 2021 Social Media Landscape Report for South Africa, which was quoted in Business Tech, found that Facebook is the most popular social media platform in our country, with an estimated 27 million local users. However, despite Facebook having the largest base, the report found that in South Africa it's WhatsApp and YouTube who are used the most. TikTok is the fastest growing platform in the country, jumping from 5 million to 9 million. Twitter's growth in South Africa, when compared to other platforms, has been relatively stagnant, just going up 4% from last year to 9.3 million. LinkedIn is moving up. Its numbers increased from 7.5 million to 8.4 million users. In South Africa, as in the rest of the world, the reach of social media is immense. Posts are fast, in some cases immediate, and in many instances cannot be deleted, especially if somebody else has taken a screenshot of the post. Therefore, social media brings with it the importance of responsible use. The golden rule to remember is that you, as a social media user, you are entirely responsible for whatever appears on your social media accounts. The South African Human Rights Commission has stated that the increase in social media usage in the country has brought about the challenge of regulating expression that is hateful and harmful. The anonymity and broadcasting ability provided by social media has created a platform for people who wish to propagate hate speech. And I know with Twitter that you can say what you like, particularly if you can't be identified from your Twitter account, and people then do, and it's very often horrible, nasty things. Section 16 of the Constitution provides that everyone has the right to freedom of expression, which includes freedom of the press and other media, freedom to receive or impart information or ideas, freedom of artistic creativity, and academic freedom and freedom of scientific research. However, this freedom is limited and does not extend to propaganda for war or incitement of imminent violence or advocacy of hatred that is based on race, ethnicity, gender or religion, and that constitutes incitement to cause harm. So that's what the Constitution specifically excludes from free speech. However, Parliament has gone further. The Promotion of Equality and Prevention of Unfair Discrimination Act, or PAPUDA as it's known for short, is also meant to prevent and prohibit hate speech. Section 10 of the Act provides that no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be hurtful, harmful, or to incite harm and or promote or propagate hatred. Publication of such expression is allowed if the expression is genuinely for the purposes of artistic creativity, academic and scientific inquiry, fair and accurate reporting of or such publication of any information, advertisement or notice, if that is in the public interest. So basically you've got these limitations, but if you're doing it for artistic purposes, academic, scientific, you've got a little bit more leeway. Now there's a difference between offensive speech and hate speech. In March 2019, the South African Human Rights Commission found that certain statements made by Julius Malema and another member of the Economic Freedom Fighters were offensive, but didn't constitute hate speech. Mr. Malema had made various comments about white people and land redistribution, followed with further comments in relation to Indians in KwaZulu-Natal in a separate incident. Comments in relation to the Indian and coloured population groups following on the comments of the rally were also subject to complaints to the Human Rights Commission. An EFF Member of Parliament was the subject of complaints in relation to a Twitter statement referring to the then Democratic Alliance's Member of Parliament, or the Democratic Alliance's then Member of Parliament or leader, Mr. Musi Maimane, as a garden boy during a parliamentary debate. The comments formed the basis of a number of complaints to the Human Rights Commission, alleging violations to the right of equality, freedom of expression, and dignity. As part of its determination, the Commission looked at the factual, social, and historical context informing the comments. In addition, they considered judgments of the courts and the impact and effect of the comments. And the South African Human Rights Commission found that while the acts forming the subjects of these complaints may have been offensive, they did not meet the legal threshold to qualify as hate speech. Now, as you may know, we've got a Prevention of Hate Crimes and Hate Speech Bill in Parliament. It's before the National Assembly Portfolio Committee. It's been there for some time. Many people have been asking, why is it taking so long? And the reason is that Parliament was waiting for the judgments in the Masuku and the Kwelane matters. Masuku about comments about Jewish people or Israelis, and Kwelane about homophobia. And what they were looking at was particularly the definition of hate speech in Papuda. But that view would form what could be done criminally, because the Hate Crimes and Hate Speech Bill is about criminalization. The Constitutional Court gave its judgment in the Kwelane case recently, which means that now Parliament can proceed with the bill, and Masuku came out shortly after that. In a unanimous judgment, the Constitutional handed down judgment in an application for confirmation of an order of constitutional invalidity granted by the Supreme Court of Appeal here in Bloemfontein concerning Section 10 of Papuda. Mr. Kwelane was the author of a 2008 article comparing LGBTIQ plus people to animals and holding them responsible for the degeneration of values in our society. The Human Rights Commission referred the matter to the Equality Court, and Mr. Kwelane in response instituted a constitutional challenge against Section 10.1 of Papuda, which defines and prohibits hate speech. Now, the Constitutional Court did have some problem with the wording. There's a provision in Papuda that speech can't be hurtful, and they said, no, that's too wide, so it's limited to harmful, not hurtful, and that the requirements should be read together rather than separately. So they declared Section 10 unconstitutional, or that to be unconstitutional, suspended the ruling for 24 months to afford Parliament an opportunity to remedy the constitutional defect. But more importantly, the court ordered that in the interim Section 10 should be read to refer exclusively to speech that is harmful and incites hatred. So as far as hate speech, that's the test now in terms of Papuda, the civil test. So what that meant was that Mr. Kwelane's offending statements made against the LGBTIQ plus community were declared by the court as being harmful and inciting harm and propagating hatred, and thus amounting to hate speech in terms of Section 10.1. And this judgment is very much to be welcomed because it brings clarity as to what constitutes hate speech. But it's not always speech or the spoken word, often it's pictures or other visual forms. A few years ago, 2 women students from the University of Pretoria faced disciplinary action after a photo of the 2 dressed up as black domestic workers went viral. The photo showed the 2 women covered in dark paint, wearing scarves over their heads and pillows stuffed into their skirts to make their buttocks look bigger. Although the pictures were taken at a private party, the university still instituted disciplinary action against the students for bringing the institution's name into disrepute. The photos were posted on Facebook, but were soon removed. Another aspect that one needs to exercise caution is when it comes to somebody else's personal information. Personal information is extremely valuable and must be protected and handled with care. And the Protection of Personal Information Act, or POPIA, was passed in 2013 and came into operation in stages. In its preamble, it states that there's a need to regulate, in harmony with international standards, the processing of personal information by public and private bodies in a manner that gives effect to the right of privacy, subject to justifiable limitations that are aimed at protecting other rights and important interests. The aim of the legislation is to protect persons' personal information so that people do not become victims of crimes such as identity theft or other data breaches. It also relates to aspects such as direct marketing and how businesses and other institutions must deal with personal information they have in their possession. So in short, the POPIA seeks to give effect to Section 14 of the Constitution, which provides that everyone has the right to privacy. It promotes the protection of personal information processed by public and private bodies and seeks to balance the right to privacy against other rights such as access to information. Now, many people will be quick to argue that individuals posting on social media are exempt from POPIA, and that POPIA arguably only applies to juristic persons and more specifically businesses, because Section 6.1a of POPIA states that it does not apply to the processing of personal information in the course of purely personal or household activity. But they then forget that our common law and the Constitution protect an individual's right to privacy, and therefore a victim whose personal information has been published and the right to privacy has been infringed would still have a legal remedy regardless of the fact as to whether POPIA did not apply. So basically, in short, with POPIA on social media, it doesn't apply to processing personal information, information for purely personal or household activity. So your contact list on your phone shouldn't be subject to POPIA, but you may go broader than you think. So again, be careful with what you post. On the 1st of March this year, the Films and Publications Amendment Act came into effect. This act extends the mandate of the Film and Publications Board to include online games, films and publication, and it comes into operation at a time when governments all over the world are grappling with the escalation in potentially harmful content the escalation of potentially harmful content on digital platforms. It inserts a definition of social media as including various online technology tools and forms via the internet, and then I quote, such as websites for social networking and microblogging through which users create online communities to share information, ideas, personal messages, and other content. So they've widened it to include that. The Act requires producers of online commercial content to subject their content to the Film and Publications Board for classification to determine whether or not such expression is permitted online or not. It also then regulates the distribution of films, games, publications, including all user-generated content on social media and video sharing platforms. And it also introduces new prohibitions on certain kinds of harmful content, including the publication of any media which promotes hate speech or imminent incitement to violence, and the sharing of a person's intimate images without their consent. The Act provides that no person may expose through any medium, including the internet and social media, a private sexual photograph or film if the disclosure is made without the consent of the individual or individuals who appear in that photograph or film and with the intention of causing that individual harm. If an internet access provider has knowledge that its services are being used for the hosting or distribution of child pornography, propaganda for war, incitement of imminent violence, or advocating hatred based on an identifiable group characteristics, it shall immediately remove this content or be subject to a fine. And the Act gives the Film and Publication Board the power to regulate almost all online content published in South Africa, not just movies and television, as was the case in the past. So that has just come into effect on the 1st of March, so that's roughly coming up for 3 months ago. So far we've focused more on responsible use on the side of the person who's posting. But we also need to look not only at the person who's posting the content, but also the person who's the victim or affected by it. So if you are having things posted about you. So depending on the circumstances, a person who suffers harm because of being the subject of somebody else's social media posts can be protected under the Protection from Harassment Act. Harm, as defined in the Act, means any mental, psychological, physical, or economic harm. And the Protection from Harassment Act allows you to go to the Magistrates' Court to apply for a protection order. And the court is also empowered to issue a direction to any electronic communications service provider, like a cell phone service provider, to give the court the name, identity, ID number, and address of the person sending the electronic communication or email. And as well as having that protection order, you can still lay a criminal charge against the perpetrator, but use the information you got from getting the order to identify the person. And you can lay criminal charges for criminal injury or any other criminal charge depending on the nature of the case. Something we see very often in our schools is cyberbullying. Our children are much more exposed to technology than before. Various social networking sites, access to the internet and chat rooms, and a choice of mobile phone communications have changed the way in which children communicate with each other and about each other. It's also drastically altered the type and content of the information they share with each other concerning both themselves and their friends, as well as the way in which they express themselves in their communications. Cyberbullying means acts involving bullying and harassment through the use of electronic devices or technology. The psychological impact of cyberbullying is often more traumatizing than physical bullying because of the extremely public nature of the bullying. Online exposure means that the whole world can witness the victim's humiliation. And cyberbullying has led to some young people taking their own lives over that. I then just want to speak a bit about the Cybercrimes Act, which sections started coming into effect at the beginning of December last year, and that also has provisions relating to the distribution of intimate images. Now, intimate images are basically, for want of better language, largely naked pics, but of a sexual nature, showing your sex organs or whatever. And what has been happening, and may happen to you, this girl and boy can be in a relationship, communicating on social media, and she sends her boyfriend erotic pictures of herself. And then the relationship goes wrong, and he's annoyed with her, and he then starts posting those pictures on social media. So, the Cybercrimes Act provides that a person who unlawfully and intentionally discloses by means of an electronic communication service a data message of an intimate image of a person be without their consent is guilty of an offence. And Section 20 of the Act provides that a complainant who lays a charge with the South African Police for this may apply to the Magistrates' Court as well, similar to the Protection from Harassment Act, for a protection order pending the finalization of the criminal proceedings to prohibit any person to disclose or further disclose the data message, or order an electronic communication service provider whose electronic communication service is used to host or disclose the data message to remove or disable access to the data message. Now, this actual section of the Cybercrimes Act is not in effect yet, but will be coming into effect soon. It's difficult to make broader comments. When it comes to Tsepang's question around his involvement in Fees Must Fall, look, I think Fees Must Fall was a legitimate protest. If you'd been involved in burning university property, and there were pictures of you throwing petrol bombs at university buildings or property, then that's not something that a future employer would really be that keen on. But for me, involvement in activism shows you've got initiative. You care about some things. It actually enhances your employability. But it's a question of what you do. So that's why I said if you're going to be involved in protests around the extinction movement of climate change, sure, go for it. But if you do anything damaging, then not. The question about government officials having Twitter accounts. Yes, I know exactly where you're going, and I'm not going to comment on particular individuals. I'm going to speak more generally. But basically, Twitter's a source of information. I mean, you will have, many of you may be social influencers. You go out to get a following so that you can influence people. And that's what politicians, government officials, particularly ministers, deputy ministers are doing. And you may not agree with what they're saying, but then usually you can pick a fight with them and take them on. One maybe to think of is a particular ex-minister who developed an interest, even while he was minister in a senior position, for cooking. And, it provoked, I'm sure that wasn't who you were referring to, But look, various, with due respect to the person, if they get to hear this, the dishes look really not, most of them don't look particularly appetizing. But if that person wants to tweet that, and there's been quite a take on it, and I see he's had donations recently for recipe books and different equipment, and he could probably do his own recipe book that people would buy because of that interest. So, look, it's basically, as long as you're not being offensive, racist, misogynist, homophobic, whatever, then it's free for all. Basically, you can post what you like and then put up with the reactions that people have. Your reaction, I think, a lot of politicians do it, is to block. So you will see people complaining that so blocked them, and what did they do? They just asked this question and then the person blocked them. So yeah, so I don't think they should be restricted. I think it's a fair engagement. I don't know if I've covered everything. Yeah. So, just on the labour law issue, I think you have asked Ms. Bloom that one. I would have thought that, and as I said, the relationship between the university and the students is something you as students need to engage the university on, and there needs to be transparency on what the rules are, and if they're not fair, then presumably the human rights section of the department can assist the students going to court on the issue. But yeah, I would have thought that when it comes to, it's natural for an employer to want to check, as they would check your references. But my own view would be, if there's going to be something adverse that they're going to use against you, they need to put that to you. That so-and-so, I saw on social media this picture of you at this function, what's your response? Rather than saying in the interview panel after the interviews, no, we're not appointing that person because they were doing this and that. I would think that is unfair, that they need to have the opportunity to know what's being said against them and to